Good night, Miss Weeks. Thank you so much for having me again.
Yes, sir. Yes, sir. I must tell you that people were calling me the morning after and just saying that they learned so much on the show, as they always do. But on this particular issue, they were very, very happy that the way it was broken down and they were able to understand it. And also that they felt really good to know there was a fresh voice, a lawyer who was, coming out and educating the people and calling the people to stand up. And so I want to, on behalf of the people, I want to say thank you for that, sir.
You are most welcome. Your viewers are most welcome. I like what you say, the people, because I believe that this is about the people, that I am one of the people, you are one of the people. And when we are looking at something this important that affects everyone, it is important that we make sure that our government is doing the best job that it can be for the people. So anything that I can do to help, I'm here tonight to review. I'm here tonight to answer questions to make sure that the people understand what is happening in our government.
Yes, and on that note, I'll remind everybody, and I'll put up the number as we go along. The number is 236-7000. 236-7000. You're calling from overseas. You can do a WhatsApp call, which will be 1-246-236-7000. Where do you want to start tonight, Mr. Greenwich?
Well, I want to start where we left off. After I joined your show on Friday night,
Yes.
obviously the House was in session. The House of Assembly was in session all day Friday, and I would not have been able to listen to the session live. And then I went into some meetings, and then I joined your show. Having joined your show, I went back and I listened to every single hour of the presentation of the Attorney General, specifically around this piece of legislation, because I wanted to match up what was being laid on the floor of Parliament to what my understanding of the bill is. And I want to say to your audience tonight, to you, Ms. Weeks, and I say it unreservedly, that there were many instances in which the presentation of the Attorney General, at best, was misleading to the House of Assembly. I'm going to say that again because I don't want
Mm.
anyone to mistake. There were many instances in which the presentation of the Honorable Attorney General to the House of Parliament on Friday was misleading. And as
Misleading. So for me as
misleading,
an ordinary person, listening to you, I know you're I can tell you're a very diplomatic person. Um, uh, you said it was misleading. As the ordinary person, can I ask a question? Was the Attorney General lying to the public?
well, Ms. Weeks, you describe me as diplomatic. It's not necessary diplomacy. What it is that when inside of a bill, you can say something that's true without giving the full picture. So that's why I'm very careful to use the word misleading, because if I tell you right now that I'm getting up from my office and I am going to Bridgetown and it would take me 10 minutes, I may tell you something that's true,
Mm-hmm.
but I've not told you if my office is in St. George, or if my office is in St. Michael, or if my office is in Warrens. So I have not necessarily given you all the information. So if you are to rely on the information that I'm giving you, you may not be able to make a decision based on the information that's given you simply on the small bit that I've given you. No, I have not lied. I've given you the bit, but I'm not giving you all of it.
I've omitted you omitted something.
I omitted something. So
Ah,
therefore, my comments at best are misleading. One may have to then ask, was that omission inadvertent? Was that omission something that was done purposely? I cannot get in the mind of the presenter at that time. All I can do is tell you that all of the information was not laid before the House of
mhm.
Parliament on Friday.
All
I
the information was not laid before. Okay, so you're gonna you tonight, you can you fill in those sections for us?
Most certainly, and it will be part of our review of what we spoke about on Friday. So, if your producer could play the first clip in order when we spoke earlier,
Yes.
so we
So
can we
we
can
played
discuss.
the first clip, Dave. I think he had it up there. And in the meantime, guys, this is going to be very important. We must listen, because this is why This is why you need an opposition. This is why you need an opposition and why we need to support what Honorable Rod Thorne is doing. Go right ahead, Dave. Thank you.
The only individual who can authorize the interception of communication is the Chief Justice of Barbados, or if he's not available, such other judge as he would assign. So you have to literally go to the highest authority. Under this act, there is no minister who can authorize interception of communications. There's no junior functionary who can authorize interception of communications. Only the Chief Justice or such other judges he assigns is able to authorize the interception of a communication. If an interception of a communication occurs without that, that is unlawful, and the person who is guilty of unlawful interception can find himself liable to a term of imprisonment of 7 years or to $500,000 in fine, even if that individual is a police.
So my first comment tonight to your viewers and your listeners, the Attorney General said in that clip just now that if any interception of communication occurs without a warrant or without going to the judge, that is unlawful. And a person who is guilty of that unlawful interception is subject to either a fine of $500,000 or to 7 years in prison or both. That can be seen in section 5.1 of the act, and your producer can bring it up on the screen.
Section 5.1. And what page is that?
Nine,
page
section
9.
5.1, yes.
Section 5.1, page 9.
Yes.
Folks, are we watching and listening?
So in section 5.1, the Attorney General is correct that an unlawful interception will attract a fine of $500,000 or term imprisonment of 7 years or both. And the Attorney General is correct that a lawful interception is one that is sanctioned by the judge. But his words were, if an interception of communication occurs without it, that is unlawful. However, the part that he is not saying is that that is not the only way that an interception of communication can occur. In other words, an interception of communication that's not done by a warrant is not the only interception of a communication that is lawful. So the suggestion in his first clip that we showed is that the only lawful interception of communication is by a warrant. That is not true. There are other instances that are lawful interceptions that are not by warrant, that does not attract, I beg your pardon, a fine of $500,000 or 7 years in jail.
Let me pause you there. So give us an example. So just break it down to a WhatsApp message or something like that, that make sure we understand what you're saying.
What I will do, I'll do one better. Play the second clip so I can extend the point, and I'll bring it all home.
Great. Okay. No problem.
Let's play the second clip.
So you want the second clip. Go ahead, Dave. Right. We need the audio. No. Not hearing. Okay. So while he fixes
while he tees it up, I will actually quote the Attorney General. He says, "It is against the law to intercept communications." I think he has the clip.
So the bottom line is this: it is against the law to intercept communications. The only exception to that rule is if the Commissioner of Police or the Director General seeks and obtains a warrant from the Chief Justice or such of the judge as he might assign.
So I'll repeat what the Attorney General says. He says it is against the law to intercept communication. So what this bill does is that it criminalizes the interception of the communication. Earlier in the Attorney General's presentation, he made it clear that interception of communication was happening all along. And it was happening all along because he himself opined, he gave an opinion that the right to privacy was not necessarily a right that was justiciable. By that, it means that it was in the Constitution, but that was not a right that allowed for an action if that right was infringed.
Mm-hmm.
He said in his earlier presentation that in 2018, the Caribbean Court of Justice, through the case of Verna and the Queen, ruled that that was not true. So the CCJ disagreed with his opinion that in truth and in fact, the right to privacy was enshrined in the Constitution and it was justiciable. By justiciable, we mean that if that right is infringed, I, Corey, yourself, Marcia, any of your viewers, if our right was infringed, the CCJ say you can bring a constitutional action in the High Court for the infringement of that right. The suggestion, therefore, by the Attorney General was that this was happening all along and it was not illegal. That's true. What makes something illegal is that there has to be a law on the books in the criminal code that makes it illegal to the extent that there is a sanction if that thing is done and it makes it criminal. So there was no law on our books that made wiretapping a criminal offense. This law does that now. So he's saying we are now putting this in place to make sure that that wiretapping is illegal. We are trying to protect you. But that is not entirely all of the story. First point I want to make is that the CCJ in 2018 gave a ruling that the right of privacy was justiciable. It gave a ruling that I could go to the High Court and I could file an action if I felt that my right to privacy had been infringed. The question begs, why did the government wait 8 years to put legislation in place to criminalize what the CCJ already says was something that was already, the CCJ had already ruled that I had a right to privacy? What you're saying to the Barbadian people is that for 8 years, this government sat and allowed my rights possibly that could have been infringed without bringing law to the law books that would make that criminal. I'll move on from there very quickly. He then says that the only exception to the rule, the only exception to the criminal position that interception of communication was now criminal, the only exception to that is if it is done by warrant. I'll repeat, this is the words of the Attorney General. That's what he said. It's a true thing, but he has not given the full picture, because that is true. If you get a warrant to do a wiretapping, it's not an illegal wiretapping, and that's what the Attorney General is saying. However, I'm going to ask your producer to go now to section 5.2 on page 9. And we're going to refer to something that we learned on Friday. 5.2 says that a person does not commit an offense in this section. So that means that a person is not committing an illegal act by wiretapping. A person, if he wiretaps, he's not committing a criminal offense for these things. And there are enumerated A, B, and when you move to page 10, it goes all the way down to C, D, E, or G. So the Attorney General says the only time that wiretapping is legal is under a warrant. But that's not true. Because here in the Act, it tells you 1, 2, 3, 4, 5, 6, 7 things that a wiretapping is legal. The first one here in A, the communication is intercepted in obedience to a warrant issued under 7 and 10, which means that the Commissioner of Police goes to the judge and gets a warrant. But it's not the only thing. B is a wiretapping that's not illegal. C on page 10 is a wiretapping that's not illegal. D is a wiretapping that's not illegal. E is not illegal. F is not illegal. And I want to pause here. On Friday night, I taught your viewers a very simple word in law.
Yes.
If you look at the end of F, those 2 letters have now appeared again, or are.
Or,
so when
yeah.
you put it all together, what it is saying is, if a person does a wiretapping, it is not illegal if A, it is done by a warrant. B, C, D, E, or G. So all of those conditions, any one of those conditions that are done by wiretapping is not illegal. Not illegal. Yet the Attorney General stood on the floor of Parliament and said only one exception makes it legal, and that's by warrant.
So in essence, he just talked about 5A and he did not do 5A1. Is that it?
Correct. So actually, the only one that he identified
2A.
was 52A,
52A.
which is by a warrant. And I repeat the Attorney General again. If you want to play the clip again, just to make sure I don't misquote him.
Yeah, Dave, which one you want played? 1 or 2?
Two.
Number 2. Play number 2, Dave.
So the bottom line is this. It is against the law to intercept communications. The only exception to that rule is if the Commissioner of Police or the Director General seeks and obtains a warrant from the Chief Justice or such of the judge as he might assign.
The only exception is if he seeks a warrant. So conveniently or otherwise, the Attorney General has left off B, C, D, E, F, or G. The most serious one that he has omitted, Ms. Weeks, as I alluded to on Friday, is B, 52B. And I want all of Barbadians that are listening to me tonight, put on your social media 52B. This is the problem that we are having this week. The Attorney General stood on the floor of Parliament, the House of Parliament. And I want to remind Barbadians, the House of Parliament is not for the 30 members that have gone in there to sit down for the term. The House of Parliament is the people's house. And I call it the people's house because when elections are called in this country, we go to the polls and we select a representative to go in our house to represent our interests in that house.
Mm-hmm.
The Attorney General, the duly elected member of Parliament from St. Joseph, is in the people's house, and he has a responsibility to properly represent the people in the people's house. The Attorney General stood in the House of Parliament and said clearly, the only exception is by warrant. Let's go to section 52B. Section 52B, and this is a recap because we spoke about this several times on Friday.
Yes, hashtag 52B, guys. This is it. This is what he left out.
This is what he left out.
Listen to what he left out. Wow. Go ahead, sir.
So the wiretapping is not illegal if it is done by this authorized officer. And we pointed out on Friday night that authorized officer are two persons: the Commissioner of Police,
yes,
and the Director General, the Anti-Corruption and Anti-Terrorism Agency.
Yes.
Those two individuals. Remember, we have "or" that's at the end of this list. So it's not saying wiretapping and this thing and no. You can select or any one of these conditions, A, B, C, all the way to G. So B allows the Commissioner of Police and it allows the Director General to effect wiretapping that's not illegal in the interest of national security, for the prevention or the detection of any offense set out in the first schedule, for the safeguarding of the economic well-being of the state, or for the purpose of giving effect to an international treaty. So I want to reiterate to the viewers, the Attorney General says the only legal way to wiretap is via a warrant. And ladies and gentlemen, citizens of Barbados, that is not the case.
General seeks and obtains a warrant from the Chief Justice or such of the judge as he might assign.
That is not the case. It is not only by warrant. The Commissioner of Police can effect legally by this act a wiretapping without
a warrant. It's a warrantless.
Warrantless judge. 52B.
Wow.
And it goes on to say, if that communication so intercepted, so that that interception of communication has already happened, can now be used to go to the judge to get a warrant. But that is
after
not
the
easy.
fact. After the fact. Uh-huh.
Because the original interception is not admissible as evidence in a criminal proceedings in a court of law. The Attorney General has to come to the people. Allow me, Ms. Weeks, to make a direct appeal to the Attorney General. And I don't make this appeal because I am any one person of any importance. I'm not. I'm simply a citizen in Barbados. I wake up every morning, I feed my dog, and I go to work like every other Bajan in Barbados so that I can feed my family and I can put a roof over my head and I can send my son to school. So my standing, and he will understand what that means, my standing to make an appeal to him is simply as a citizen of Barbados. And I say to him, return to the floor of the House of Assembly, of the House of Parliament, and explain to the Barbadian people what is meant by 52B. That is my appeal to the Attorney General. Don't take my word for it. You return to the House. If you inadvertently omitted to mention that it is not only by warrant, but that the Commissioner of Police and the Director General can effect wiretapping without a warrant. So maybe you misspoke. So I am asking you kindly, sir, return to the House of Parliament and explain to every citizen in Barbados why that the power has now been given to two functionaries to effect wiretapping without a judicial warrant, without judicial scrutiny. Ms. Weeks, after we spoke on Friday, I also went and checked the other legislations. I chose the three largest economies in the Caribbean community: Guyana, Trinidad, and Jamaica. I'm happy to report to you and your viewers tonight, yes, there is similar legislation in all three. In Jamaica, it was the 2002 bill. So this is nothing new. That is 23 years ago. In Trinidad, it's the bill of 2010. And in Guyana, it's a 2008 piece of legislation. In Guyana, in Trinidad, there is a similar provision as 52B. So in Trinidad, it allows for warrantless interception. In Jamaica, however, that section was removed. That section does not exist in the Jamaica legislation. And I think every Barbadian needs to say to the Attorney General and all 28 of the members of the House of Assembly that stood behind him and supported this bill, that we insist that 52B be removed. These functionaries should have to go, even in an emergency situation, to go to the judiciary in order to receive a warrant, in order to wiretap, intercept communications of the people of this nation. We sent these 29 representatives to the People's House, and they must act in the people's interests. The Guyana bill is neutral. The Guyana bill allows for wireless interception, but only under very clear emergency situations. So to wax poetic that this legislation is all over the Caribbean, again, is slightly misleading, because here you have in Jamaica, that section has been removed from the bill. 52B, we're asking the Honorable Attorney General to return to the floor. This bill has now passed the floor and is heading to the Senate. This bill now is heading to the Senate for the 21 senators to vote on whether they're going to allow 52B to remain, whether they're going to, they themselves, who are citizens of this country, to allow warrantless wiretapping of citizens of Barbados. And I am saying that every single senator that is sitting in the upper house of Parliament, whether the government senators, whether the independent senators, and most certainly these two senators in opposition, to vote against this bill. It should not remain in its current form. The Attorney General should come to the House and amend this bill and remove Section 52B, such that what he said then becomes the absolute truth, that the only way that the Commissioner of Police can legally tap citizens of Barbados is through a warrant, which is issued by the judiciary or the judges in the High Court of Barbados. I want to go on to point out one other scenario. You can play the third clip.
Wow, folks, listen, we've got to. He's saying to speak to the senators. I think what we're going to do while we're getting that other clip to come up on the screen, we need to write to the senators. We need to write to them. We need to write to our MP. We know the section that we want out of that bill. It is 52B. It's clear. We want that out of the bill, folks. Get writing tomorrow. The Senate is on Wednesday, folks. Write to your MPs. Flood the senators with emails tomorrow. Very important. Go ahead, sir.
But we're trying to say to the citizen, we understand the intrusive nature of what this is, but we have to give you certain guarantees. We have to guarantee you that only people who have a role in criminal activity can have their conversations liable to be intercepted. That's the first thing that this act says. Because you must tell the judge what is the crime that you are either detecting or looking to prevent. So unless the judge is satisfied that the individual whose communication you want to intercept is a part of a criminal activity, then he's powerless to authorize it. So then people sit in earshot today and wonder, well, so does this mean that they can come and intercept my communication? The answer, sir, is no. The answer is no, because unless you fall within the four corners of this act, you don't have a thing to worry about. So let me reiterate, for all of the many thousands of Barbadians, the many tens of thousands and hundreds of thousands of Barbadians who are law-abiding, they have no need to fear this bill simply because this bill only allows for the interception of communications in an instance where an individual is involved in the criminal activity that we've outlined in the schedule. Plain and simple.
Now, I played this clip because the Attorney General gives the thousands, the tens of thousands, and hundreds of thousands of Barbadians a guarantee. A guarantee. And I don't know if you know the saying, Ms. Weeks, that a promise is a comfort to a fool. And I know that the Barbadian people are not foolish. So let's look at this guarantee. He is guaranteeing the thousands and the tens of thousands and hundreds of thousands of citizens of Barbados that the only way in which your communications can be intercepted is if you are part of a criminal enterprise of some sort, and a judge has an opportunity to make a determination of your involvement, or at least reasonable suspicion of your involvement in criminal activity. A judge. The Attorney General guarantees the people of Barbados that a judge would make that determination. How can he guarantee that a judge makes that determination if 52B allows the Commissioner of Police to execute interception of communications without having to go to the judge itself? Is the Attorney General misleading the people of Barbados? Is he misleading the House of Parliament? Does he believe what he's saying and have not gone into the bill himself? I don't know. But these are the questions I have to ask, because he makes a guarantee. A guarantee, Ms. Weeks. When in 52B, it is clearly set out. Clearly set out. And by the time now that we have talked about this, I am hoping that even the layman, this is no longer in the realm of law, the layperson can read it for themselves. It says that the communication is intercepted by the Commissioner of Police or the Director General in the interest of national security for the crimes that are listed, for the well-being of the economic well-being of the state, and to effect a request under an international treaty. So he does not have to go to a judge. Yet the Attorney General stands in the House and he says, I guarantee the thousands and the tens of thousands and the hundreds of thousands that you don't have anything to worry about. I appreciate the attempt to bring comfort to the nation, but that comfort has to be backed up by what is actually in the bill. And 52B is the comfort to a fool. Are we foolish, Ms. Weeks? I am hoping not. Let us speak truth to power.